Right now on Law&Crime Report, a police-involved shooting left a 29-year-old man shot in the back 7 times. Miraculously, he survived, but the shooting has renewed protests and calls for police reform.
Wow!
Plus, the man known as the Golden State Killer has been sentenced to 26 consecutive life sentences. Though he eluded authorities for 40 years, it was DNA evidence that ultimately brought him down. We discuss.
And I'm really sorry.
And later, it's been 1 year since the tragic death of Elijah McClain. We revisit what has happened since. This is the Law&Crime Report, diving into true crime and all legal stories making headlines. It's Tuesday, August 25th, 2020. Good afternoon, I'm your host, Brian Buckmire, here at the Law&Crime Report, and what a set of stories we have for you today. Let's jump right into it. First, the story of Jacob Blake. This was the case where we saw some footage of an individual out of Kenosha, Wisconsin being shot not once, not twice, but 7 times in the back after he attempted to go back into his vehicle. Let's begin by looking at a clip, and then we'll start from there.
Wow!
All right, so that is the clip. From what we're understanding, that was a video that was posted by an individual who lived just across the street. They said they saw an altercation between the officers and this individual who learned was Jacob Blake. They were fighting, they were wrestling, and he believed that halfway through, because this doesn't show everything, it just shows about endish of this interaction, he began recording. Now I'm joined with Judge Birmingham, a Texas District Court judge, as well as Lisa Lockwood, veteran SWAT and police detective. Good morning to you both, or good afternoon, sorry.
Good afternoon.
Well, I guess good morning for Lisa and afternoon for Judge Birmingham, depending on where you are. But Lisa, we have seen these videos over and over again, and we've looked at it from different lenses. Tell us what this looks like from the lens of a veteran SWAT and police detective.
When anything is isolated from the lens of seeing that video recording, just that incident, it looks like a hot mess. He was getting into the vehicle. The police officer had enough distance from him. Could he have went for cover, etc. The things leading up to it is what we need to see. The officers were called to the scene for a domestic incident. Upon arrival at the scene, and we don't know if dispatch had already called and told them the background of the individual who was shot, Mr. Blake, were there weapons offenses in his background? Did he have a checkered past? Was he extremely dangerous? Was he known for fighting the police? So police officers a lot of times are armed with that information as they arrive that they need to exercise more caution. The other thing that we hear is that drop the knife was being called out prior to us seeing that footage, drop the knife. We also know that he was being fought. There is video evidence of a fight from somebody else at another angle, allegedly with police officers trying to get him into custody, punches being swung at one another. And then what we see is Mr. Blake actually leaving to try to get away from the police is what it looks like.
Now, Judge Birmingham, when I look at this, a lot of people are saying, well, he was just walking away, he's leaving. So the first thing that pops to my mind is DeBoer. What was the level of suspicion the officers had to say that he was either detained or couldn't move or couldn't leave? That's what comes to my mind. Right now, we're really in the evidence collecting phase. As Lisa put out, there is a lot of information here or there. As a judge, what information are you looking to gather to kind of make heads or tails of how Lisa put it being a hot mess?
Well, the video is a wonderful tool to show exactly what was happening and who was in what vantage point. And I think what you're going to see that this case is going to come down to eventually at a trial, and I'm going to go ahead and guess this case is going to come down to a trial at some point, is what was the officer perceiving when the man opened the door, Mr. Blake? Is the officer going to say that he felt like he was lunging for a weapon that he thought might have been hidden in the car? Was that belief reasonable? Again, we come back to that word reasonable. What was reasonable or not in the eyes of the officer according to the jury or the community, the regular man on the street? Was it reasonable what he did? 7 times in the back, the video, I'm glad we have it. It's going to be played numerous times during the trial. I think the other thing to remember is that the other officers that were on the scene did not shoot. Their perception might have been exactly the same, and jurors are going to be considering how they reacted as well.
Yeah. Now let's take a listen to LaQuisha Booker. This is Jacob Blake's fiance giving some words about the interaction.
You overused it. That's what you did. You shot him numerous times for no reason. It didn't take all that. Disregard that my kids was in the car at all. And you knew they was in there because I kept screaming that before y'all even made it to the other side of the driver's side to get him in the car. I've been yelling that the whole time. Let me get my kid.
All right, so Lisa, I want to field this question to you first because a lot of people like to Monday morning quarterback officers and say, you could have done this, you could have done that, you could have done that. One that rings a little bit true in my ear that seems odd. I totally understand what Judge Birmingham is saying, and I think as a defense attorney, if I was representing these officers, that's my argument. He's reaching into a vehicle. We don't know what he's reaching into. A lot of people are looking back and saying, like, well, why did you let him get to the vehicle? Why did you do this? Why did you do that? Can you kind of give us a mindset of what the officer's going through to maybe answer some of those whys, why, and why? Like what could be going through their mind at that time?
Sure. So you have initial resistance. One, you have a domestic situation. Two, we have somebody who is allegedly armed with a knife. Number three, you put up a fight. He was also tased, is my belief, and that didn't work. Now you have somebody who is attempting to flee from resisting custody. Now, on top of that, he's going toward his vehicle. He's walking away. People look at, police officers are trained, vehicles can be deadly weapons. What was interesting, though, is the way that he went into the vehicle. It wasn't an attempt to sit in the vehicle. Nobody generally goes head first into a vehicle. So that is what I think is a little bit concerning because all police officers are trained on, furtive actions, reaching for what's out of the norm. So the police officer who was tight in that close proximity, what we see on his body cam, what we learn about what his thoughts are regarding an immediate threat is what still needs to be discovered in this case.
Yeah, still I got to look into that. And Judge Birmingham, but we get the video and it shows an action that I think is somewhat troubling to say the least. Let's use that word just as a bottom line. There are 3 children in the car. They're shooting him from point blank. It's 3 officers and 1 individual. They had, at that point, already, as we're hearing, wrestled him to the ground and tased him. And at least at that point, he didn't pull any weapons. So why isn't this a scuffle between officers and an individual on the ground rather than 7 shots point blank in the back? Is that something that we should be asking as well?
Sure. Everything that you're talking about was the conduct of the officer at the time, given the information, reasonable to a reasonable person? Was a reasonable reaction? And that's what you're talking about. Should they let him get all the way around the car? Should they have shot? Is there some other reasonable means that they could have used instead of shooting him in the back 7 times? Those are the types of questions that jurors are going to be asking when they're analyzing this case.
Yeah. It's going to be interesting. Well, first we got to see if charges are even pressed, because again, we're getting that there's an investigation both at the local level, but they also want to bring it to the state level and maybe larger. Again, this happened in Kenosha, Wisconsin. We're going to take a quick break and come back with more stories here at the Law and Crime Report. Welcome back. So if you were watching Law and Crime last week, you have saw 3-4 days of victim impact statements for the Golden State Killer, where victim upon victim told their chilling stories about how this person ravaged an entire community, raping and murdering countless numbers of people. Okay? Thankfully, due to DNA evidence and a little bit of luck from that of a straw, they were able to find this individual. He pled guilty not only to the charges that were originally associated with him, but also admitted to others. Let's begin by listening to some of the victim impact statements, because one of the more pressing ones were that of the Harrington brothers, those who lobbied for the state to have a state DNA database, which eventually led to the arrest and conviction of the Golden State Killer. Let's listen to their words during the victim impact statement.
There were countless trips by the remaining brothers here to Sacramento before the Public Safety Committee. We were just trying to change the laws in efforts to increase the DNA database. Older brother Bruce testified before the Public Safety Committee Keep in mind, these are just private citizens trying to make our laws better in the interest of public safety. First issue, the use of reasonable force to obtain DNA samples from the prisoners that refused to give it. Sounds easy. There was a buzzsaw of opposition. And as an example, there was the infamous confrontation between older brother Bruce and Senator Burton. But there was a bigger issue. It was not just obtaining DNA samples from prisoners, but obtaining DNA from all convicted felons and DNA at the felony arrest level. As you could tell, it became clear that the legislature was not interested in dramatically increasing the DNA database. Nothing was going to be accomplished in Sacramento. If the legislature is not going to change or make new law that dramatically increases the DNA database, what do you do as a private citizen? The only option is to put an initiative on the ballot and have the public vote on it.
So Judge Birmingham, let's begin with you, because this is an interesting discussion that came out of the Golden State Killer case, where we're talking about the benefit of DNA. And DNA is helping in a lot of ways. It's exonerating individuals who are wrongly convicted. It's solving cold murder cases. But there's also this lurking fear that people have. And when these brothers talked about a DNA database for people just who are arrested for felony charges, that to me kind of sounded like nails in a chalkboard. I'm like, what happened to the presumption of innocence? Talk to us about this kind of DNA conversation that we're having nowadays about both its strengths, but also some of its flaws.
Well, there's constant tension in the law. Everybody is demanding answer and resolutions to cases when they happen. But it's on the other side, there's the inevitable invading of the privacy of the citizens. And that's really the tension. I don't have any problem sharing my DNA on a database because I'm not going to go out raping and killing people, you know. And so some people on the other side say, well, you know, that's the price that you pay to solve these cases. And there have been tremendous victories by DNA evidence, as you said, in exonerating people and also in solving cases. I spent 15 years of my career doing just that. So there's great power in it. The tension, though, is how much of your rights are you willing to give up? And I got to tell you, I love the dogged determination. These guys would never let anything other than the truth coming out in these cases for their brother stop them, and they didn't. And man, they are to be commended for that.
Yeah, and I think that's what makes this discussion so difficult for people to have. Because Lisa, I'm looking at this case and I'm looking at all of the victim impact statements, and I keep coming back to, if we did not have this DNA database, we might not have come to this point. But then I also look at it on the other side, and I think to myself, there are people, even officers, for example, when I have a case in New York, the officers don't give their DNA to cross-reference with guns or other objects because they themselves say, I'm not quite sure if I want to give up this level of privacy for that reason. And I can understand people's privacy arguments. So it's a true debate that has strengths on both sides. Lisa, what are your thoughts?
It's true. It's a complete paradigm shift as far as tools in law enforcement. And this tool is so incredibly helpful. The Harrington brothers, what they were able to do, and as far as legislation after the Golden State Killer case and this coming out, their doggedness, it should be just so rewarded. Police officers now having that tool, propagating the DNA database in order to solve cold cases, current cases, the list goes on. Protect people as far as Project Innocence, getting people exonerated for cases that they were wrongly charged. So I'm an advocate in all of that. But Just like facial recognition, people are fearful for privacy being taken away. The innocent is fearful of that. So yes, I agreed with you when you said, as a defense attorney, for somebody who is just charged with a felony and having their DNA taken automatically without any consent is troublesome.
Yeah. And then Judge Birmingham, the other question becomes, because like the brothers were kind of alluding to, those inmates who do not want to voluntarily give DNA. I know even in New York we have this problem at times where you're convicted of a violent crime and the law, and it makes sense in that narrow situation to get DNA. The question then becomes, how do you get DNA from a person who does not want to voluntarily give it? That creates another issue as well of use of force in the prison systems. Any thoughts about that?
Well, as long as in the collecting process, protocols are followed and there's the process of collection is transparent and accessible to the public so that there's no secret, there's no abuse of it, perhaps some judicial oversight. I know that in Texas, I sign a lot of search warrants for that very purpose. And, you know, the law should allow for officers, when a lawful order from a court or an order that is contemplated and allowed under the law should be able to be carried out, but it has to be done so in reasonable circumstances only and with reasonable measures. And as long as they're followed, then what else are we going to have? You can't have a law that's going to be ignored either. I mean, you know, so you've got to allow officers and the system to work within the confines of those things that it's been allowed to do by our legislators.
Yeah. And I'll add on to that, Your Honor, as well, is that the Fourth Amendment typically, or it does say it's supposed to be the least intrusive measure in which you would take that DNA. I know that we're not putting needles in people's arms anymore because we've decided that that was far too invasive. I know now we're doing more swabs of the mouth, maybe hair removal. Maybe there's a way of making that least intrusive, get as least intrusive as possible. I know the Honor here pointing. I don't know what to do then, Judge. We're going to shave everyone's head. I don't know.
I mean, hair removal for some, not for everybody, Mr.
Yeah.
Buckmire.
We can't all pull off that look as well as you can. If I would, my shampoo bill would be a lot cheaper. But let's take another look at the presser in the Golden State Killer case after the sentencing of those 26 consecutive life sentences after he was found guilty.
Bruce and Ron Harrington testified yesterday in front of the court on their victim impact statement. And one of the things they shared is since the advent of investigative genetic genealogy, we've solved 93 cases throughout the country. That probably would have gone cold forever. When they, prior to introducing Proposition 69 in 2004, there were 1,200 cases solved because of DNA, and now there's 81,000. So I appreciate the question from the Los Angeles Times. I know it's a national periodical, but of course it covers Orange County because I'm just adjacent to Los Angeles. And I want to say this unequivocally. And they said it yesterday, I'm just repeating the words of the Harringtons. That is something that DNA is something I'm going to fight for till I go to my grave to make sure we continue to collect DNA from every felon arrested in the state of California. It has brought more closure to more victims than the advent of anything since the fingerprint. So let's get clear about that. Investigative genetic genealogy has been an eye-opener, and it brought closure, as much as you can give that term, to this case. It was the linchpin that solved this case. I will never make excuses, but some of us are supporting a bill in the California legislature for opt-out on voluntary genetic databases, and the leadership of Anne-Marie Schubert and Greg Totten to come up with guidelines which govern the law enforcement use of how we use DNA. You should check out that periodical and that excellent work, both practical and academic. As prosecutors, we are abundantly protective of people's civil rights and the right to anonymity with respect to the use of DNA. We also know in the balance as government officials, sworn elected officials, that it has also been the biggest eye-opener to the solution of cases to give some peace and some opportunity to people sitting in here today who would have no closure, not even anything close to it, if we didn't have the advent of those two tremendous advances in law enforcement.
All right, so again, Judge, I think you were kind of posing it correctly. This is a balance between, like anything in the criminal justice system, safety and privacy. And it's always a shifting scale. And so it appears that I don't think there's going to be anyone that's going to have an argument that we shouldn't have some sort of DNA or use of DNA in the criminal justice system. I guess the question just becomes the how. And I guess for you, Judge, I would ask, and I'll ask the same with Lisa in a moment, what is the how? Like, how should we be doing this to create that proper balance between privacy and safety?
I would suggest to you it'd be the same way that we considered going into somebody's house and doing search warrants. Perhaps there's got to be some judicial oversight, maybe a bright line rule that everybody who's arrested gets their DNA taken without any oversight or request. You know, maybe that's not the best solution for it. Maybe there has to be some kind of a warrant that can be secured for that purpose. So judicial oversight, we always go back to transparency. That's another part of it. And then finally, what they were touching on in the press conference, and that is that the information that's gleaned has to be regulated and only used for a very specific purpose, and it can't be used for anything else. Now, I don't profess to know exactly how to define that, but I think the idea would be for law enforcement purposes, we do have a database to expand that database and only to use it for that database and for purposes of solving crime.
Yeah. And then, Lisa, it seems to me that as we talk about police enforcement and criminal justice, I agree with Judge Birmingham, but now we're giving the police officers another task, another role. Should this be something that we should be asking officers to do on top of all their other duties? Or is this something that we maybe do separate and apart? Maybe the officers do the arrest and the procedures and they bring the person in, and then we have a separate entity that will add in the judicial oversight that the judges are suggesting? Or is this something we just say, all right, our men and women in blue, here's another task we're going to throw on top of you?
Yeah, it all depends if it is mandated, because during an interview process, before somebody is even arrested, we have seen suspects actually voluntarily give their DNA and their swabs to police officers and hair samples. Later on, when it gets into the interrogation, is where you have issue with that, where they have obviously an option to decline that. Well, even in interview, they have an option to decline, but when you're in interrogation, now there's a period of, is it necessary because of the mandate that if you are arrested for a felony, you will give that DNA information to the police officers. So they have been doing it already. To answer your question, police officers have been retrieving it. They're in a situation where they're building rapport with the individual in an attempt to get a confession and get that incredible evidence from that suspect.
Yeah, and I get it. The states will follow the laws in which they elect, and they have. I know in New York we do a similar process. But we do it after conviction. But the public defender in me still says innocent until proven guilty. If they're convicted, sure, because my fear is if you get that DNA from them and they are found not guilty, what happens to that sample? And I've seen records that are supposed to be expunged, not get expunged, but pop up. Warrants are supposed to be expunged that pop up. And the fear of having your DNA still there if that record is expunged, dismissed, or you're not convicted is one that I think that people are arguing on the side of privacy is an issue. And I think the devil's in the detail here, and that's what we really got to work out here. But thank you for that conversation, both of you. Let's take a quick break and come back with more here at Law and Crime Report. All right, so as we watched the Golden State Killer, a lot of emotions were felt. On one part, we found the person who committed atrocities across a community for so many years. On the other end, when you listen to some of these victim impact statements, there were so many unanswered questions that form of catharsis almost seemed stunted by the fact that so many questions went unanswered. We joked here saying there's got to be some sort of true crime special. Someone's got to pick this up. Someone's got to answer these questions, because it really felt like there was justice, but with a bit of a question mark for many of the victims who came forward. Let's listen to the prosecutor who spoke about the possibility of there being other crimes, and let's talk about how this story might not be done just yet.
On this case completed, because I've spoken to one of the special agents that investigated this in Sacramento, and he said there were still rapes, murders that he believed was linked to Joseph DeAngelo, but hasn't been proven yet.
I mean, I think we'd all probably collectively say, and many of the folks like Erica Hutchcraft from Orange County, Paul, Ken Clark, Larry Poole, who have dedicated their lives. I mean, we know what we know, Rowena. That's where'd you go. We know what we know. We know, you know, because of the power of the data bank that the Harringtons brought to us, we know what's been put into it, and we know what's been linked. Does that mean that there are not other crimes out there? Absolutely not. I don't believe we will ever know the magnitude of what Mr. D'Angelo did.
How certain are we that he stopped committing these crimes in the late 80s? And if he did stop them, can you offer any insight as to how someone like that might have been able to stop them? And did it bleed out and did it push out in other ways in his life? You know, since then, were there other signs? I'm just curious what your insight is.
I think I tried to answer that earlier. I don't think we'll ever know. I mean, honestly, on the day of his arrest, I got a text message from a colleague of a Wikipedia article about when did forensic DNA come into existence, and it coincidentally was 1986. And so, the question needs to be posed to Mr. D'Angelo.
All right, let's bring this right to the veteran police detective. Lisa, this is a question that I think bothers a lot of people, because while we see that there was this kind of trajectory of his crimes that he started committing, all of a sudden, at least if you're looking at just the allegations here and the victims here, he stopped. But the question becomes, why did he stop? Or did he actually stop? And it's a question that I think is really bothering a lot of people, but also, I don't know if it's one that can ever be answered. What are your thoughts?
Yes, the reporter posed great questions to the prosecutor, because with that DNA information that we now have on file, if the police officers were able to go back in those vicinities, the areas that he lived, and look to see in those prior rapes, in other unsolved murders, if they can link any DNA that was collected and put into evidence back to our Golden State Killer. So it is so large. He's got 161 confessions to crimes. Certain ones were chargeable, then we had statute of limitations. But to get the closure, to have police officers who are dogged, who say, you know what, let's go ahead and open up some of these cold cases and see if we can resubmit DNA to try and find out if he was linked to those. And this could just, tedious work, but could go on and on if we have the right personnel to do it.
Now, Judge Birmingham, you are a judge. You've sat in court. You've rendered decisions. You've given sentencing. Talk to us about the gravity of a 26 consecutive life sentence and how big that is, considering all that we saw and all that we heard. And I think also how rightfully it applies in this situation.
Well, the crimes themselves, each individually, as they've been described, are horrific. And 26 life sentences, seems to be, in the eyes of some, not enough, because, they did not go for the death penalty in this case, and I've heard some chatter about that. But I think that the important part of this is to make sure that what do people expect in a sentence like this? That he ever gets out again? Well, that sentence would certainly ensure that he never does get out again. He's in his 70s now. He's never going to outlive 26 life sentences that are consecutive. So there has been some measure of justice. And I think, that's one thing. What has happened to the guy? What's happened to the defendant? The other thing that's important, though, I think in our criminal justice system, is closure to the victim's family. Have they learned everything that they are entitled to know, that they could possibly know about what happened to their loved one, to their mother, brother, father, whoever it was that was hurt? And to a certain extent, there is value in being able to explain to the family members of the victims what happened as best as law enforcement can.
Yeah. Absolutely. Now, let's switch gears ever so slightly, because we're talking about another cold case that's picked up some traction. We're talking about the murder of Jason William Mizell. Most people would know him as Jam Master Jay, the DJ for the famous group Run DMC. Now, the Brooklyn native was murdered in his studio on October 30th of 2002, and while there were suspects in this what was believed to be a cocaine deal gone wrong, it wasn't until recently that Ronald Washington and Carl Jordan Jr. were arrested for charges of murder while engaged in a drug trafficking, where they're facing about 10 counts in Brooklyn court, in the federal Brooklyn court, sorry, where they're facing a minimum of 20 years. Let's go to the acting U.S. attorney to get more details on that.
I also think it's important in this time for us to recognize that there are certain crimes for which the passage of time affords no safe harbor, and murder is one of them. We've charged this case with respect to Mr. Jordan as a drug-related homicide and the use of a firearm in connection with that offense, and the same charges apply to Mr. Washington. Also with respect to Mr. Jordan, we've charged a conspiracy, narcotics distribution count, and 7 substantive distribution counts. But primarily, this is a case about a murder that for nearly 2 decades had gone unanswered. And so today we begin to answer that question of who killed Jason Mizell and why. And we're confident that we can prove those charges beyond a reasonable doubt.
All right. So another cold murder case, but through an investigation, they end up finding the 2 suspects. Lisa, let's begin with you. We're hearing reports that the arrest was led by the Queens detective, FBI, and ATF. This seems to be a pretty well-coordinated arrest, but it's also one of them that is like just so famous. We all know about the murder of Jam Master Jay or Tupac or Biggie, so there's a lot of eyes on this, and now we're finally getting some resemblance of moving towards justice. What do you make of this investigation? What do you make of this arrest, and how long this took, and probably how in-depth it was as well?
And the expectation that it would never be solved, just like you said with Biggie and with Tupac, because in that community, and it's a dangerous community where you're dealing with drugs and weapons charges and burglaries and robberies and distribution and all of that, we know the saying goes, snitches get stitches. So it's so dangerous. They can be executed for testifying. Even victims themselves who are shot don't want to point a finger at the person who did it for fear of retaliation to themselves and to family members. So having this resolution right now with this investigation to come to a place where we do have charges against these individuals is incredible. It's nothing short of a miracle.
Yeah. And another, I mean, Judge Birmingham, another cold case. I know that both you and Lisa are fans of Jam Master Jay and the music Run DMC. What are your thoughts about this? Getting some sort of inkling towards, all right, we've kind of maybe solved it. Let's put the pieces together and let's see how this plays out.
It's going to make for a fascinating couple days of testimony at some point. You know, in cold cases like this, jurors understand that not every crime is solved within the first day, you know, and the passage of time is significant. It's going to give the defense some leeway. It's going to give them some arguments to make. But what you're going to see is laid out in a very methodical manner. Why did this case grow cold? What leads were chased down? When did it begin to point to these 2? And why did it begin to point to these 2? And then what happened? What did police later learn to corroborate or confirm the things that they did? And that's always a fascinating journey for me whenever I watch detectives who testify about the life of an investigation. Some investigations are shorter than other ones. This one happens to be about 18 years old.
Yeah. And now, Lisa, just based on the nature of how this occurred, Jam Master Jay is in his Queens studio in Jamaica, Queens, when he's shot and killed. So the assumption is it must have been someone who he knew. The family was always said it was an inside job. In fact, Ronald Washington is not unfamiliar with this kind of belief that he's either a part of this murder or others, because Washington was a suspect in the 1995 murder of Randy Walker, who was an associate of the late Tupac Shakur. And he previously denied both shootings, that to Randy Walker as well as Jam Master Jay. And Washington actually lived with Jam Master Jay at one point when he fell in hard times. So you bring up a good point of snitches get stitches, and it might be hard to get those interviews and speak to people. But how do you put this all together when there's so many missing pieces? And this happened almost 2 decades ago.
Oftentimes the police know who the killers are. It's just a matter of getting the evidence to go forward with it and getting the people who are going to give them their testimonials, their witnesses on what happened. So that's the hardest part in all of this. thinking about what's going to happen to them. Are they going to testify? Can they give their statement without going and taking the stand? And you can't. We know that that's not possible. So the danger, as I mentioned before, in this community with drugs, with weapons charges, with robberies, everything that surrounds it, it's so volatile, it's so dangerous, and having it come together the way that it did is incredible with the joint forces, as you mentioned, with all the law enforcement agencies that have been involved. The thing that people are going to think is, are they going to play them against each other, Jordan and Washington? Are they going to give a deal to somebody? And my guess is that that's not going to happen. It's just too dangerous.
Yeah, I could definitely see this going towards trial, but also because of the age of the case and maybe the lack of witnesses that the prosecution might have, it might be, for lack of a better word, a little tricky for them to prove the case. But we're going to continue with more here at the Law and Crime Report right after this break.
Stop. Let go of me. No, let go of me. Chill out. No, I am an introvert. Please respect the boundaries that I am speaking. Relax. Stop. I'm going home. Relax, or I'm going to have to change this situation. Dude, leave me alone.
Sir, can you please cooperate?
You leave me alone.
No, we're gonna talk to you.
You guys started to arrest me, and I was stopping my music to listen. Now let go of me.
You guys.
I intend to take my power back, and I intend to be centered. No, I intend to be centered.
Just grab your gun, dude.
Stop, dude. Give us more. Give us some more units. We're fighting them.
So yesterday, August 24th of 2020, marked 1 year after Elijah McClain, and that video occurred, was killed. And 1 year later, the question has been, for many people, is what has changed in that community when it comes to policing, and what has changed in terms of the seeking of justice for Elijah McClain. Many felt that this was a tragic incident where the reports are that he had, he was somewhere on the spectrum of autism. Even some of the words that he spoke, I'm different, don't touch me. Many people who are familiar with autism could identify right off the bat that he was trying to articulate himself in a way that people are trained to do so, and the officers, either not recognizing it or ignoring it, acted in a way that was harmful to him. Again, I'm joined with Judge Birmingham as well as Lisa Lockwood. Judge, let's begin with you. It's been 1 year since this incident. What are some of your thoughts in the year that we've seen, and in a year since his death, but also what we've learned and heard about the story of Elijah McClain?
Well, the criminal case itself is obviously very, very tricky, as you used the word earlier, because you don't have a cause of death that is attributable apparently to one person or the conduct of the police. And without that, it's really hard to prove a homicide case. Let's look at this, though, from a public policy perspective. Did the police handle this? The actions of the police officers, were they consistent with best practices? Were they consistent with best practices not only for how they interact with citizens, but how they interact with citizens who have special circumstances? And I would say most people would think that there would be the need to enhance the training in situations like that for these police officers to recognize and deal with the situation differently. And I'm hopeful that even though there may not be a criminal case from a public policy standpoint, that there have been changes and enhancements to the way that the police interact with people in this area.
Yeah. And Lisa, this was new to me. I'm not sure if it was new to you, but the use of ketamine to calm a suspect who was going through that what they were describing like a kind of like a fugue state and pushing him off, that was new to me. And that, as the judge was saying, it's really hard to point to one contributor to his death, and that's why they're having issues with any potential criminal case. What did you make of some of the tactics that were used here and the request of the officers to the EMT to use that drug to kind of sedate him?
Right. So asking to use that drug was based on their experience with him. Initially, you can see, I think it's evident to anybody, even without training, that you had somebody who was special needs by the dialogue. And initially, the police officers seemed to say to him in a very calm way, just listen to us, we want to talk to you, just listen to us. And he was getting aggressive and heightened in his verbalization and wanting not to be touched. And all of that makes sense to somebody who has special needs. Where all bets were off when the police officer said he's going for your gun or his hand was on your gun. Whether a person has special needs or not mentally disabled, that becomes a position where you put a police officer in as far as the threat that was perceived in that moment. The ketamine aspect of it, the officer using the street knowledge that they have, saying we've seen cases like this before where somebody became highly excitable, et cetera, and offering that as a solution to the paramedics. And paramedics ultimately have the decision of what they're going to do based on their own observation, whether or not to give that drug to stop the effects of what they believe was happening as far as a mental breakdown.
Yeah. Now, that incident had a lot of question marks for people, and still a year afterwards, we're not seeing any movement in the criminal case. And as the judge said, it's predominantly because of the cause of death. And that's something that a lot of people are saying, well, we saw the video, we saw what exacerbated it. Well, the report says that wasn't the main cause of it, but that's where we are now. However, after the incident, I think salt was rubbed into the wound based on some of the reenactment photos that officers were sending around. And I think that's what really pushed people a little bit more where they were already pushed on this incident. Let's take a look at that.
It's reprehensible, and that's why they no longer work here. I would like to give you some information about those officers. Kyle Dietrich, which is depicted in the photo. He has been on the Warren Police Department for 3 years, since 2016. Jaron Jones, depicted in the photo, he has been on 3 years, also 2016, and he is the one that resigned. Erica Marrero, depicted in the photo, has been employed for 2 years and was hired in 2018. The last officer that I fired received this photo and replied with an inappropriate comment of ha ha. There was absolutely nothing funny about this. That officer is Jason Rosenblatt. He has been on for 3 years. He is not being involved in this because of him being in the incident of the photo. He's being fired for his lack and utter inability to do the right thing here. And to say ha-ha when he was engaged in the incident with Elijah McClain is absolutely unacceptable.
All right, so those officers were fired, but also to point out what Judge Birmingham was saying earlier, there were a lot of changes, and there are a lot of changes in that area. The governor signed a new police accountability law on June 19th called the Enhanced Law Enforcement Integrity Act, which bans the use of chokeholds and carotid holds, chokeholds being directly on the windpipe, carotid being on the side of the neck by police. It also mandates body-worn cameras by the police be used and bars the use of deadly force against those suspects of minor or nonviolent offenses and requires officers to intervene when they witness another officer using excessive force. We've only got about a minute left. I want to thank you both for joining us, as well as obviously our audience. Judge Birmingham, final thoughts as we talk about Elijah McClain. And also I want to add, we just got word via Benjamin Crumb's Twitter that Jacob Blake will be permanently paralyzed from the waist down, but they're hoping and praying that's not permanent. So just final thoughts on this show for today.
Well, first of all, thanks for having me again. I think that what you see as part of the cause or the catalyst for civil unrest in our country is that for so long, people have been treated in an undignified manner. But now we're seeing, hopefully, the restoration of dignity of the citizen when they're interacting with law enforcement officers. And I applaud Vanessa Wilson for taking swift action. And that conduct like that should not and would not be tolerated from our police officers.
Yeah, all right, I want to thank you very much. Sorry, Lisa, we've got to head out, but I'll make sure to catch you next time when we're back. Thank you for joining us, Lisa Lockwood, Air Force vet at SWAT and police detective, as well as Judge Birmingham, Texas District Court Judge. Thank you both, and make sure to continue with our regular scheduled program right after this here at the Law and Crime Report. We'll see you guys all tomorrow. Have a nice day.